Okay, thank you so much for joining us. I'm going to do some brief introductions while a few more people come in from the Zoom waiting room. My name is Marie Colbeth. I am the Vice President of Privacy and General Counsel here at SixFifty. And with me today to present the webinar is Austin Smith. Austin works on data privacy issues for SixFifty. He focuses primarily, I actually shouldn't even say this anymore. I used to say it on the CCPA and CPRA and GDPR, but with the new Virginia and Colorado privacy laws, he's been turning his attention there as well. So he works on essentially all privacy issues. Before joining us, he advised companies that range from tech titans to small startups in his work at law firms. And also before that, he worked on Capitol Hill, where he would brief members of Congress and their staff on privacy issues. Austin graduated from UVA Law School, and he clerked for the federal court in the Eastern District of Virginia. Interesting fun fact about Austin, he's also a cat parent, and I'm wondering if his cats had the opportunity to dress up for the most recent holiday or not. Austin?
Unfortunately not. They are not the type where you can get them to do anything, but
maybe next year. We're also joined on the Q&A today by another one of our colleagues, William Frescus, who's a graduate of BYU Law School. And before joining us, he was general counsel for Encircle, which is a multi-million-dollar nonprofit organization that supports LGBTQ youth and their families. While there, he was the strategic expert on legal advice for everything from employment and business law to diversity and inclusion, and of course, privacy, which is why we scooped him up here at SixFifty. So we have a lot of expertise to help answer your questions today. As we go through the webinar, if you do have any questions, we encourage you to submit them via the Q&A tab at the bottom of your screen. That way we can keep track of them and hopefully answer any questions that we're able to get to, and we'll send out answers to those we're not able to get to. We also have available the regular chat. That's more like if you're having technical issues. So we're going to get moving into the webinar, but again, it will be recorded and sent out later. So if you're looking for a slide deck, that'll come in the follow-up email. So with that, let's be off to the races with our webinar. Good, thank you. So quickly, we collected questions beforehand, and we'll also take questions today. One of the main ones, though, that we saw replicated over and over again was just sort of regarding what some of the main differences are between certain privacy laws. So today we're going to focus on California, Virginia, Colorado, the EU, or Europe, I should say, and China, each of which have a really substantive privacy regime either in place or coming into effect soon. So Virginia and Colorado will both have their privacy laws come into effect in 2023. California's is already in effect, but they do have a substantive change happening starting January 1st, 2023, with the CPRA, which amends their current law, which is the CCPA. And for those of you that are in the international space, China's privacy law, the PIPL, just went into effect on the 1st of the month. So that's a brand new one that we're dealing with. So just sort of generally, questions start off usually with applicability. When do these laws apply to your organization? When do they not? We've given you the serious breakdown in the slide deck. I'm going to hit some of the main points. But like I said, you'll get the slides later so you can focus in on the nuances. Main points with California are that if you're collecting and processing the data of California residents and you meet one of the threshold questions. So threshold questions are you have 25 million or more in annual revenue, and that's based on your previous year's revenue. You buy, sell, or receive the personal information of at least 50,000 California residents or California households, or at least 50% of your revenue comes from the sale of personal information of Californians. And so that's the current threshold for the California law. Starting in 2023, the threshold changes a little bit. Instead of having to meet one of those requirements, there's still the $25 million potential threshold, or you could meet a threshold of having buying, selling, or sharing the personal information of 100,000 or more California residents or households. So that threshold number goes up in 2023. And instead of deriving 50% of your annual revenue from the sale of personal information, that changes to you derive 50% or more of your annual revenue from selling or sharing the personal information. So it expands a little bit there in terms of what counts for your revenue cap. So that's California. The other US jurisdictions are really similar in how they do their jurisdictional rules. So for Virginia, if you are conducting business in Virginia, or you're offering products or services that target residents in Virginia, and here's the threshold questions, you control or process the data of at least 100,000 consumers from Virginia, or you control and process the data of at least 25,000 consumers, and you also derive more than half your revenue from the sale of data. So really similar to the California rule, but with a little bit of variation, because instead of each of the thresholds being an or, the last one is an and, where you have to both control and process 25,000 users' data and get your revenue from that data. Colorado, similar again, but again, it can be a little more broad. So Colorado, first off, if you conduct business in the state of Colorado, or you produce products and services that are targeted towards Colorado residents. If you're going with B to become susceptible to the law, you also need to meet one of the thresholds, which is again $100,000 consumers, or deriving, revenue from the sale of their personal information. So U.S. jurisdictions care a lot about, how many of their residents' data you're processing, how much money you're making from it, if you're making money from the processing, and then just finally, how big you are overall and whether you're located in the state. If you're located in the state, that's pretty much going to make you susceptible the majority of the time, unless you're in California and you're a really small business. So then we move to Europe and China. Europe basically says, if you touch our residents' data, we want to control you. So if you're a data controller, established, or processor, and you're in Europe, and you're processing any European's data, it applies to you. If you're outside of Europe, and you're processing the data of anybody inside of Europe for the purposes of offering goods or services in the EU, or monitoring the activities of anyone in the EU, then it applies to you. So essentially, like, if the reason you're collecting the data of European citizens is because you're selling something to them, you want to sell something to them, or you want to figure out what their behaviors are, so you can analyze those behaviors, the law will apply. And lastly, China. Essentially, if you're processing the personal information of any Chinese resident while inside China, it applies to you. And if you're outside of China, it applies to you if you're processing that data for the purpose, like in Europe, of providing products or services to people in China, of analyzing the behavior of anyone in China, or a catch-all if there's some other law or regulation they pass later that says, yeah, it applies to you too. So a lot of catch-alls there. But essentially, if you're processing the data of individuals in a jurisdiction, whether or not you are in that jurisdiction, there's a high likelihood it's going to apply to you. There's some exemptions though. So let's talk about exemptions for a minute. Thank you. We need to know what personal information it applies to and what personal information it doesn't apply to. So essentially, if you can link the personal information directly to an individual, or if you can link it to a household and identify that individual or that household, in essentially all of the jurisdictions, it's going to be considered personal information. However, it can be a little more broad in some jurisdictions than others. So for example, in California, if I'm processing information that's been pseudonymized, I have a hard time saying that word, I'm so sorry. If you're processing that kind of information and you don't have any way to re-identify the info, it's not considered at that point to be personal information anymore. It's been de-identified. But if you're in Europe and you're processing that same info, it's probably still PI unless it's been completely anonymized. So instead of putting in a pseudonym and having a key somewhere in existence, the fact that there's a key somewhere in existence means it's still covered by Europe's GDPR. So you can't get away with just using pseudonyms in Europe to say this data is no longer covered by the law. So some differences there. Essentially, in US jurisdictions, if you're processing publicly available information, then it's probably not covered by the law. You just have to make sure you're meeting the requirement for what's publicly available in that state, because those definitions change a little bit. If it's fully de-identified and anonymized, then it won't be treated as personal information in any of the jurisdictions. And if it's information that is regarding deceased persons, this is an interesting one. Some jurisdictions don't really address that. Europe specifically says if they're deceased, the law doesn't apply to them anymore. China specifically says that if they're deceased, the law still applies, and their next of kin has the ability to exercise the deceased person's rights to their data. So really interesting. US hasn't really gone in the direction of dealing with that to the same degree at this point, but some nuances there. And then we'll talk a little bit more about, so we know jurisdiction, we know what data is being covered. Now we need to think about some exceptions and exclusions. And this is where it can get tricky across jurisdictions. So in the US, there's a strong interest in treating data that's employment-related data differently than people's personal information that's related to their non-employment activities. So, when I'm out there acting as a consumer and I'm purchasing products for myself, the US wants to treat that, US jurisdictions want to treat that differently than when I'm representing my business and I'm engaging in activities where I might be, purchasing something, signing a purchase agreement for my business. So the first one in the US is treated as covered personal information. The second one is not. So in California, Virginia, and Colorado, there are exceptions for situations where a person is acting as an employee or a contractor, as a job applicant, as a business owner. Those situations are exempt. So my employment data, I can't send my employer a request that says, hey, delete my data, because that employment data is exempt. However, in Europe, that's not the case. Employment data is covered in Europe. China allows you to process employment data, but it does require you to have a legal basis for doing so. So it's sort of more of a gray area in China, but you do have to meet all the requirements for data protection for employment data. So it's not really exempt in China either. So one thing to keep in mind, though, is with California specifically, that exemption for employment data and for business to business personal information is only good until January 2023, unless the new California Privacy Agency implements a new regulation that extends that exemption. They're supposed to. They've been given the direction that they're supposed to do that, but we haven't seen it yet. So also, just so that you know, the B2B exemption in California, it generally doesn't apply if the personal information is collected unless the employee is acting on behalf of their employer in order to provide or receive a product or service from the second business. So if I'm at work and I'm on my work computer and I'm buying stuff for myself on Amazon, that's not subject to the B2B exemption. But if I am on Amazon and I'm buying something in my employer's Amazon account, we have a business account, then I'm acting as an employee purchasing something for the business. That personal information that they're collecting is subject to the B2B exemption. It's not covered by the CCPA. Some other general exceptions that are similar across jurisdictions is, generally speaking, in the US, if data is subject to a different data protection regulation like the GLBA or HIPAA, it's going to be exempted from coverage by the state-specific laws. Some other like specific exemptions are if you're a higher education institution, you're exempted in Virginia. You're also exempted in Colorado, but not in California. If you are a state agency or political subdivision of the state, you're exempted in Virginia and Colorado. If you're a nonprofit, you're exempted generally in California and Virginia, but not in Colorado. In Europe, there's no exemption for nonprofits. There is an exemption for government agencies and law enforcement when they meet certain requirements. And it also doesn't apply to the processing of personal data by the governments themselves, the EU governments themselves, if they're also meeting some specific requirements. And then in China, a question that we do get a lot, the Chinese law, the PIPL, does not apply to special administrative districts, so Hong Kong. So if you're collecting information about Chinese residents in mainland China, the law applies. But if you're collecting it about residents in Hong Kong, the law does not apply because they're a special administrative district. An interesting caveat there, a lot of companies have offices in both, and they'll transfer data back and forth between those offices. If you're sending the personal information about a resident in mainland China to Hong Kong, that's considered a third country transfer essentially, and you have to meet a lot of requirements for transferring the data out of mainland China, even though you're just sending it to Hong Kong. So a lot of differences between the different laws. And they get, those are the generally recognized main differences. If you have more specific questions, we'll try to get to some of the ones that I saw come in the Q&A. I will say just sort of, these are overarching differences. There's also some main ones that will affect your operations. And so we're going to talk a little bit. We had some that were submitted talking about the operations. And so I'm going to talk about opt-out rights first. And so opting out is kind of more important in the US than in Europe and China, because Europe and China are much more interested in opting in. So in California, I, as a consumer, would have the right to opt out of the sale of my information. You have, as a company that's covered by the California law, you have to have a little link, that says do not sell my personal information. You have to give me the right to opt out. Starting in 2023 in California, consumers will also have the right to opt out of targeted advertising or profiling. So that opt-out right is going to expand in 2023. Not just in California, but also, Virginia and Colorado's laws come online in 2023, and they also require you to offer the right to opt out of sale, targeted advertising, or profiling. And so those three will all essentially match each other in that sense, starting in 2023. In Europe, you really have to be careful because they require you to have a legal basis for any processing of information that you do. And so a lot of companies make their legal basis consent. They say, okay, we have customers, our customers have all consented to us doing these things, and so we're going to base it on consent. You have to keep in mind that, they have the right to withdraw that consent at any time, in which case you would have to stop processing if you had based the processing on the fact that they consented. So sometimes companies will use other legal bases, such as, they're doing the processing in the public interest. Maybe, they're running some sort of historical or statistical analysis, and they're processing data for that. And so they might say, oh, it's in the public interest. Or they might just say, well, it's in our legitimate business interest. In those two situations, individuals in Europe have the right to say, it's like an opt-out. They have the right to ask you to stop processing while a determination is made about whether your interest the public interest or the business's interest do in fact outweigh that individual's interest because they want to say no. They want to say no, don't process my data. And so while that determination is made, you do have to stop processing their data. So it gets restricted while the supervisory authority would look into that. So it essentially acts like an opt-out. China, same thing. They have the right to withdraw their consent. There's also the right to limit or refuse the handling of personal information generally, unless there's a law or other regulation that says they can't object. So essentially, Chinese citizens' rights reflect pretty closely European citizens' rights in those senses. So there's some differences there. The US is pretty consistent internally in limiting things more strictly, whereas Europe and China say, no, we want to pretty much let people opt out or object at any point. So some really major differences there. And now I'm going to turn it over to Austin to kind of talk about some of the questions that we got about how you might still see across those jurisdictions some competing requests coming in.
Yeah, thanks, Marie. So one of the questions we got, which applies to all of these jurisdictions, is what if you get something like a do not sell request or an opt out of processing request and a deletion request from the same customer? The best case scenario there is if you can delete everything, you don't need to keep it for any reason, then that handles the do not sell or do not process. However, in most cases in real life, there will be a little bit more complication. For example, maybe you have already sold a product to an individual and they ask for both do not sell and delete their data. And you have a return period of 6 months or a year. And so you need to keep that information on hand in case they want to return their product. In which case, you probably wouldn't want to delete that information. And in your response, say, hey, we've deleted you from marketing emails or whatever it is, but we're keeping you on this list for returns or warranty. And then you, in the meantime, need to make sure you don't sell that information if you do, or share it in ways that aren't allowed under a do not sell or stop processing list, and kind of mark it as delete this in a year in the future or whatever it is. So that can get pretty complicated when there's multiple requests that come at the same time. Another one we see questions about is if someone submits an access and a deletion request at the same time. Those aren't mutually exclusive necessarily, as long as you don't delete the things first. So especially if your process is that people can't submit more than one request on a single ticket. If you see, if someone on your team sees, oh, there's a deletion request and we can delete everything, and then they go ahead and delete it, and someone else sees later an access request in the queue and says, wait, we don't have any information on this person, that could be a problem. So ideally, you would have a process in place to make sure that before you delete someone's information, you look whether they have any other requests pending, like an access request. So the takeaway lesson is you need to have processes in place to handle a variety of requests that come in any order or at the same time. And another major question we get is specifically with US laws. If I'm complying with the CCPA, does that mean that I'm okay under Virginia and Colorado as well? And the answer is no, definitely not. But the good news is that you have gone at least half the way and done a lot of the heavy lifting. The most obvious example being data mapping. If you're complying with the CCPA, that means that you've looked through all of your systems and identified what data you have and how you're using it. And that can absolutely be leveraged for requests and compliance with Colorado and Virginia's laws. But again, you definitely need to make some changes. A few of the examples, this is absolutely not exhaustive, is that Virginia and Colorado require an appeal process, which we'll get into a little more later on for if someone makes a request and you deny it. The CCPA doesn't require that kind of appeal. This is within your company sort of internal appeals process. And Colorado is going to require recognition of universal opt-outs, which again, we'll get to a little bit further on in this presentation. And that starts a year after the law in general goes into effect. But that will definitely be something that you probably aren't already doing for CCPA compliance. Data protection impact assessments, DPIAs, which are basically balancing tests of benefits and harms, are required in Virginia and Colorado, and even in California when the CPRA goes into effect. So even if you're complying with the CCPA in California, you're going to need to make changes anyway soon because of the CPRA coming into effect at the beginning of 2023. And then related question is, people ask, any future state laws, any proposals out there, are they pretty similar, or is there anything kind of coming out of left field? So far, there hasn't been anything that's brand new, that's completely different from the CCPA or Virginia and Colorado general consumer privacy laws. So that's the good news, again, is that it looks like all future proposals will be sort of variations on a theme of what the CCPA and other existing laws look like. One other cross-jurisdictional point we wanted to discuss is standard contractual clauses. If you haven't heard of those, they're basically fill-in-the-blanks contracts that the EU and now UK have, and China hopefully will soon have. And if you're exporting data from one of those jurisdictions to certain other countries that don't have significant or sufficient privacy protections as those jurisdictions see it, a standard contractual clause may be the best way for you to legally export that personal information. Again, it's just a contract where you fill in, who are the parties and, here are the protections we're providing and things like that, which is why they're standards. The EU has new ones that just came into effect a month or two ago. The UK currently uses the old GDPR EU ones since it left under Brexit before those new ones were approved. And they're not as ideal as the new EU ones. China, to jump all the way into the alphabet soup here, PIPL SECs are AWOL. The PIPL being China's law, they have said that standard contractual clauses will be provided for exporting personal information out of the country, but those have not materialized, even though the law went into effect 2 days ago. So it's unclear when those will be coming out, but China has said they will. So the bottom line is that these contractual clauses for now are not between themselves standardized. You will likely need to take into account each jurisdiction. You can't just use one contract for exporting from all of those jurisdictions.
And I think that's oh, sorry.
No, I was just going to say, Marie can take it a little farther with what these SCCs really are.
And I would say this is one of the most annoying things about the competing jurisdictions when it comes to privacy law is, one data processing agreement doesn't get you across the line with every jurisdiction because they're so different in what they're requiring you to do. With GDPR, we have had several specific questions asking us about the new standard contractual clauses that have come out and that are now in effect. So if you are exporting any personal data out of the EU into a non-European Economic Area country, you need to be using these, most likely. So if you have new contracts, new vendors, new partners, people that you're sending data to that you didn't have a pre-existing data processing agreement with, you need to use the new standard contractual clauses starting, these went into effect on September 27th. If you have pre-existing contracts with, partners or vendors that you're sharing data with, taking it from the EU to a non-EU country, and you've already got data processing agreements in place, you can continue to use those old ones that were based on the old standard contractual clauses until December 27th. sorry, can you go back? I wasn't quite done. I started at the bottom of the slide. And that's a typo on the slide. It should say December 27th, 2022. So they're essentially good for a year and 3 months after the new date of effectiveness. So you, like I said, you can keep them, but you need, like, when it's time to renew those contracts, or if they're for longer than a year, you can't actually keep using them beyond the December date. The reason that we have these new standard contractual clauses, Austin sort of touched on, the old standard contractual clauses didn't really account for all the different ways that companies work together and share data. So the new ones allow for 4 scenarios: situations where a data controller is exporting information that they're sending to another data controller, situations where a controller is exporting to a data processor, or where a processor is sending the data to yet another processor, so a sub-processor, or where a processor is sending the data to a controller. So, some examples of each of these. If I am a multinational organization, I have employees in Europe, my European office is sending some HR data from that office to my headquarters in San Francisco. That's a controller to controller transfer of data. If I'm, that same European entity, I'm sending data, like that same HR data, to my benefits system, and the benefits system servers are all in the US, maybe because corporate headquarters is in the US. I'm sending it to that benefits processor, my payroll processor, whatever it is. So that's a controller to processor sharing or transfer. If I am, the benefits provider, and I'm collecting data from those European employees, and I'm the processor, I'm just the provider, and I'm sending it to yet another processor that's going to, take some further actions. Maybe, I run, the system, but I have a sub-processor that's actually interacting with banks so that people can get their paychecks, processor to processor. And then processor to controller, I'm the benefits system, and I'm sending reports back to the company that owns the data. That's processor to controller. So there's situations where you could be, as one entity, you could really stand in all of these positions potentially. And the new SCCs allow for that. They allow for you to account for the different positions that you as a company might represent in different data situations. So that's why we have these new SCCs, and it is important to use them. They're going to do a better job for your company than the old ones did. The old ones were very clunky.
And on that note, the EU and UK, we get a lot of questions after Brexit. What differences are there? The SCCs, as mentioned before, are the biggest difference by far right now. And as Marie noted, while the EU new SCCs have all 4 of those situations covered, the previous versions, which the UK still has, are not as easy to work with in all those situations. So you kind of have to shoehorn them into the right place, although the UK is certainly working on its own SCCs, which hopefully will be similar to the EU's and cover all those situations well. And other than that, the 2 regimes under the UK and EU are very, very similar. Almost all the requirements are the same. And so other than the SCCs, there's kind of that rift, and they're only kind of slowly drifting apart. You can think of it as kind of continental drift, very slowly. But the UK has said, some politicians have said, we want to make some significant changes, and the EU has responded with, well, if you make too many changes, you might not be considered a country where exporting doesn't need SCCs, that you have adequate, similarly adequate provisions as the GDPR does. So something to watch if the UK does make big changes to its laws. That continental drift change could just be a rupture. So worth keeping an eye on, absolutely. And the last point on this is, because the UK and EU are now separate privacy-wise, if you're operating in both, you may need a designated representative in each one. And that gets into some details we don't need to hit on, but if you needed a representative in the EU for the GDPR previously, and you're operating in the UK, you very likely might need one in both now.
Yeah, and that's, if you could just click one more time so we get the text, thanks. That's an interesting point, you know, the designated representatives for the two, like a lot of countries, a lot of companies used to just have one, right? And now you might need three. You might need one in the US, the UK, and China, and maybe Brazil. Like it's just growing so much. But so now I'm going to move more specifically. I'm going to transition us over to like focusing on some of the US laws. And I'm going to start by looking at California. I think the most questions that we get, other than when there's a brand new law like China, that we've gotten really consistently, and that, you know, we reviewed in preparation for this webinar, are about the CPRA, which is a new California law that goes into effect on January 1st, 2023. And one of the specific questions that I wanted to make sure we answered today was, you know, what exactly that means with it going into effect on January 1st. And what that means is all of the new, you know, there's some expanded consumer rights and things that consumers receive those rights on January 1st, 2023. But with that, that means there's a look back period that actually will look back to January 1st, 2022. So just, you know, 2 months from now. And what that look back period is for is specifically for the right to know or the right to access a consumer's data. So if I'm a consumer and I'm submitting a request to a company saying, I want to know what information you have about me. Right now, under the CCPA, the business has to look back 12 months and say, okay, over the last 12 months, what have we collected or processed about this person? And I need to tell the person, this is the information. And I need to also tell them if I have shared that with third parties. What's changing a little bit is what I have, and there's some other things I have to tell them. There's a long list, but this is going into what's changing. With the CPRA, I have to tell the consumer not just who I've shared it with, but I have to tell them about the categories of service providers and independent contractors that I might have disclosed it to. So before, I might have been saying like, oh, you know, I shared it with my affiliates, I shared it with my partner companies, because, you know, we all have a data sharing agreement. But if I also am using service providers to process the data, I now need to disclose, you know, what are the categories of those service providers. So everything from, you know, my system, my platform is sitting on AWS. So my actual platform provider, to, you know, I might have service providers that are, you know, event management systems. For example, if I'm running events and I'm collecting consumers' information when they attend my events, it can really vary. So that's a big change. But in terms of effective date, you know, the new rights for individuals go into place on January 1st, but because they have the right to look back 12 months, the changes in how you have to respond to right to know requests, you need to start tracking that on January 1st, 2022, so that you can answer the question on January 1st, 2023. So that's a big change. Sorry, thank you. We also received a question that was related to the CCPA that also sort of had some crossover with how our system works. So if you're a customer of SixFifty and you're, you know, creating your CCPA documents from SixFifty. So first of all, the documents that you download from your dashboard in SixFifty, they're all editable. So if you want to edit them and make changes, you're allowed to do so. We don't stop you. If those edits are substantive, so like sometimes you just are like, oh, we maybe input something in a little kind of a weird way. Let's go tweak that. You know, that's doesn't read as well as we'd like. You know, we're going to tweak it. But if you're making substantive edits where, you know, our system has, you know, given you a document that's saying, you know, the following are the ways that we share your information. And you add a new way that you're sharing information, and you don't want to go into the system. That's fine. You can make that choice. But if you're going to change something about your disclosures that could have some sort of legal impact, we do recommend that you get some legal review. Because again, like, we vetted these documents. If you're making substantive changes, we can't guarantee, what you're coming out with. But also, we had a specific question about the contract addendum document that's in the CCPA system that we thought would be helpful to answer, where the user was wondering, if we wanted to make a substantive change to what it said, would that substantive change be problematic? And we just wanted to clarify, if you are sharing data with an organization, an entity, an individual, and you're sharing it, you're not selling it to them. For it to qualify as sharing in California, you have to meet some requirements. And one of those requirements is that they have to be under contract with you. And that contract has to prevent them from doing certain things. It prevents them, for example, from selling the data. It prevents them from using the data for their own purposes. They can only use it to fulfill their relationship, their responsibilities towards you, the data owner. And so, this individual is asking us, well, what if we want to have our affiliates do some of the processing for us? And, do we have to have a contract addendum for them? And the answer is yes, you should. So if they're a service provider, if they're an affiliate and you're sharing information with them, if they're any other entity that you're sharing information with, but it's not a sale, you need to put them under contract so that they are legally required to meet all of the check boxes that they need to meet to be considered, for that transaction to be considered a sharing of information as opposed to a sale of information. So just a quick note there. Yes, you can edit our docs. We do recommend you get them reviewed if you do some substantive editing, but also in terms of who you should be completing the contracts for, you should be completing them for any entity that you're sharing data with, but not selling it to. So entities or individuals that can only use the data for the purposes you tell them they can use it for. And it's to help you perform some sort of function, not for them to have it for their own individual benefit. So that's sort of the takeaway on docs. And I will now let Austin do some zeroing in on Virginia.
Thank you. Yeah, we got a few Virginia-specific questions that we wanted to go into the specifics on. So this first one is sort of a technical or very specific question about, say there's a recruiting company that collects data for job opportunities, and they're collecting Virginians' data. So the Virginia law has an exemption for anyone who's not acting in an individual or household context. So again, I go onto Amazon and buy something, that's just for myself. That's me acting in a personal context. But if I'm applying to a job in Virginia, that's an commercial or employment context. So the Virginia law doesn't apply to that. So the scenario here sounds like it would likely be outside the scope of the Virginia law if the recruiting agency is collecting the data directly from an individual. Say they're a website that allows people to give them their information, and the recruiting agency will send it to a bunch of possible employers. However, this question wasn't entirely clear, and Marie and I were discussing, what if the recruiting agency is just scraping information about all kinds of people from LinkedIn or Facebook or just personal websites, any information, without talking directly to the person whose personal data it is. That could very well be covered by the Virginia law, especially to the extent that people weren't sharing that for employment opportunities to begin with. So it kind of depends, as unfortunately most legal questions are answered, but to the extent you're combining data from an employment context with other personal data, or getting data about people without directly talking to them, that is definitely something that could make the information subject to the Virginia law again. Another Virginia specific question we get is, what's this appeal process? I briefly mentioned before that Virginia, and then 6 months after that, Colorado will have an appeal requirement. So if someone says, hey, delete all my information, and you have an exemption, like this is a free speech situation, or we're required to keep it for 3 years for auditing purposes, whatever it is. And so you say, sorry, we can't delete it, we have to keep it. If the person disagrees with you, they can say, hey, I want to appeal directly to you, to your company. And there's not a strict deadline for when that appeal has to be entered, just within a reasonable period, but you have to make it conspicuously available. So you don't want this to just be a hidden option that only a lawyer who's familiar with the CDPA would know about. It has to be clearly disclosed to people, and it has to be similar to your regular request process. So it can't be significantly more onerous. And you will have to give a written explanation of your final decision. You have 60 days to process the appeal from when you receive it, and you have to describe that process for submitting an appeal in your privacy notice. So this is a whole new process on top of your normal rights requests that you might already be doing in California or for the GDPR. And if the appeal is denied again, even if they say, hey, I think you have to delete my data because of this, that, or the other. If you still deny it, then in your denial, you have to let the person know how they can submit a complaint to the Virginia Attorney General. So basically, there's a lot more that you're going to need to have to do to comply. Colorado is very similar, slightly different deadlines, but basically the same idea. And one thing to keep an eye on is that these laws don't specifically talk about what happens if you only partially fulfill a request. If you delete a lot of their data, but there's some portion that you don't, is that not acting on their request, as which is the language in the laws that triggers the appeal option. So that's something to keep in mind, and hopefully look to more guidance on. Then we had a few Colorado specific questions. The main enforcement issue with Colorado that people should be aware of is that it's unique in that it gives more people the right to enforce the law. It's still not a private right of action. None of the states have that, where an individual could sue if they think you violated the privacy law. But in Virginia and California, only the Attorney General can currently enforce those. Colorado also deputizes the 22 district attorneys' offices around the state of Colorado to enforce it. So sometimes AG offices have a lot of responsibilities, and enforcing privacy law might not be their biggest one. So more companies might be able to sort of slide under the radar. Colorado says that more eyes will be on potential violations, and I won't go through the details, but here's how much Colorado can fine you and how it works, and there's a cure provision, and that again, we'll be sending out the slides and a recording if you want to get into all these details. The last thing to note about Colorado is that starting in 2024, exactly a year after most of the Colorado law goes into effect, it says that companies will start having to recognize a, quote, universal opt-out mechanism. It doesn't give a lot of details, but it's an opt-out mechanism to opt out from targeted ads and sales of personal information. The Attorney General in Colorado is going to have to release regulations by July of 2023, when most of the law goes into effect, about what this universal opt-out mechanism actually is. So we'll get a lot more details then, but presumably it's similar to a do not track mechanism, which people can turn on in their web browser, that will give every website they visit notice, hey, don't track me. Most companies don't follow that currently at all. And note that the CCPA regulations currently say that businesses have to also honor user-enabled global privacy controls, which again is a very vague term, not a lot of detail on how that works, although browser plugins or privacy settings, device settings are named as examples. There's no clear basis in the actual text of the law about requiring that. So it'll be interesting to see if some companies take that to court and try to challenge it. Definitely something to keep an eye on. And worth noting that Ashkan Soltani, the new executive director of the new privacy agency created by the CPRA, has been a champion of this kind of opt-out technology, universally opting out of all tracking or sales of data for every website that someone visits. So it's definitely going to be a priority for the new privacy agency as well.
Thanks, Austin. I was going to sort of wrap up by talking a little bit about privacy and its overlap with the pandemic. We have gotten a lot of questions about this. I've been in some webinars where all we were talking about was the pandemic and related issues with employment, particularly. And we did get a similar set of questions, and heading up to this webinar. The first one, sort of one that encompasses everything I'm about to talk about, was whether vaccination status is protected by privacy law, and whether, if you're, say, for example, managing travel for unvaccinated employees, what you can and can't do in terms of what you come collect, what you might be able, how you can meet all the requirements in different jurisdictions, depending on what you do and don't know about your employees. So first off, answer number one to that is the privacy laws in the United States do touch on vaccination status to an extent. However, you are allowed to collect the information as a general rule. I'm about to dive into a lot of the specifics, but as a general rule, if you as an organization want to collect the vaccination status information of your employees, you are allowed to do that. How you do it is what's really controlled by the laws. So I'll start by talking a little bit about the CCPA. The CCPA, again, only applies to your organization collecting this type of information if you're covered by the CCPA. So if you're a small organization operating in California, but not collecting very much personal information, you have like 5 employees and you're not collecting PI as part of your business, maybe the law doesn't apply to you and you don't have to worry about this. But generally speaking, if the law applies to your organization, if you're dealing with California residents' personal health information, you need to give proper notice to both your employees and non-employees about what you're doing with it. So that notice means that you have to limit the info that you collect based on what you say in the notice. You have to limit the use of the info according to what you say in your notice. And you have to limit your sharing of any of that personal health information according to what you say in your notice. So you might be noticing a trend. Most of the impact of the CCPA on personal health information is that you have to abide by the things you say in the notice you give when you are collecting that information. You also need to afford non-employees that you collect any personal health information about a way to exercise their CCPA rights. So remember, employee data is exempt from the CCPA currently. So if you're collecting personal health information about your employees, you do not have to give them the right to, say, ask you, please delete that information that you collected from me. The CCPA doesn't require that, but it does require that they get notice about what you're collecting and that you follow the contours of that notice. You have to stay true to it. So that's how the CCPA sort of interacts right now. Do keep in mind that personal health information is sensitive information. So if we're still in this phase where we're collecting this type of info in 2023, there's new requirements in the CPRA about how to deal with sensitive information. And also just generally, you need to be more careful with it, right? So we're about to talk about why you have to be more careful about it, untethered from the CCPA. So for any organization in the United States that's subject to the Americans with Disabilities Act, the ADA, you're subject to that law if you have 15 or more employees. And that law governs the collection and storage of medical records. So what's a medical record or an exam under the Americans with Disabilities Act? So self-screening. So if people are taking health screeners to come into your business, like, do you have a fever? You know, do you have symptoms of COVID-19? That's a medical record under the ADA. If a healthcare professional is doing the screening, that's a medical record. If you're taking temperature readings and recording them, that's a medical record. Or if you're not recording them, if you're just taking them as an exam. If you're collecting vaccination cards, obviously your vaccination card is a medical record. And if you're having people self-report their vaccination status, that is also a medical record under the ADA. So with these medical records under the ADA, what you're required to do with them is keep them confidential. So there's our privacy side. They're confidential. They have to be stored separately from the employee's personnel files. And you have to store them for at least a year following the creation of the record, or for a year following termination, whichever is later. So if you collect my vaccination status today and in a month you fire me, you need to keep that information for a year after that fire date, not for just the year after the date on which you collected it. So your data retention periods can change a little bit, but those are the requirements of the ADA. These overlap in some ways with the requirements of OSHA, and I'm talking about federal OSHA. You may be in a state that has state OSHA requirements, so it might be a little bit different, but state OSHA requirements have to be at least as protective as the federal requirement. So even if you're in a state, for example, California, with their own requirements, they have to, this is the minimum, your state might require a little bit more. So under OSHA, you have to give employees the right to access their medical records. So if you collect, a copy of their vaccination card and they say, I want to see that copy, you have to let them see it. This is the hard thing. You have to retain medical records for 30 years after employment. That's an incredibly long retention period. So let's talk about what is a medical record, because it's different than the ADA. So the ADA thing with the 1 year includes more stuff than OSHA includes. So the OSHA 30-year requirement applies to some things, but not everything. So if a healthcare professional is doing your health screening, that's a medical record under OSHA. If you get a copy of a vaccination card, the vaccination card was created by a healthcare professional. So that is also considered a medical record under OSHA. Also, the results of medical examinations and lab tests. So like if you get a COVID test result from somebody that they submit to you, that's a medical record under OSHA. Things that are not medical records are self-screening and vaccination self-reporting. So if instead of keeping a copy of their vaccination card, you ask them to attest to their vaccination status, that attestation would not be a medical record under OSHA. So some differences in what you have to do in terms of, where you keep them and how long you keep the records for. The main thing to keep in mind, keep them separate from their personnel records. So you're meeting ADA. And if you have a choice, I would recommend doing self-attestation, because you have to, you don't have to keep it for as long if they attest to their vaccination status. However, just so that you're aware, I know we're at time, I'm going to finish the sentence. We do have federal standards coming out, a new emergency temporary standard, where we're going to get more instruction on who's required to be vaccinated and what you have to do in order to meet the requirements of collecting the information about your employees. So if you're an employer with 100 or more employees, this new ETS is going to apply to you, and there will be a lot more information about what you're required to do to meet it. So there may be some rules around whether you have to collect a copy of the vaccination card, or if they're allowed to self-report. And if you have to collect a copy, maybe they will relax that 30-year retention requirement. So this could change. We're expecting the ETS any day now. We have sort of like an office pool going on when it will actually be published. But and I know at least one of us has it today. So thank you so much for joining us for today's webinar. I think we have answered all the questions that were in the Q&A. So thank you to my team, especially to William, for answering those. One last comment, HIPAA. If you're wondering about HIPAA and vaccination information, just be aware it only applies to covered entities. So unless you're a healthcare provider, an insurer, a medical billing company, HIPAA probably doesn't apply to you. So if your employees say, you can't ask me that, it's HIPAA protected, the truth is you probably can ask it and it's not HIPAA information. Also, HIPAA is about the release of information without an individual's consent, not about the collection of the information. So if your employees are complaining because you're asking for stuff about, their vaccination status or about their, doing a healthcare screener, most likely you can just say HIPAA doesn't apply here. And there's other rules that do, and that's the ADA and OSHA. That's what you need to worry about. So any final wrap-up comments, Austin, on your side?
No, I hope this has all been helpful. There are a lot of questions, and we're happy to be able to answer at least some of them.
Yeah, and if you have more needs, please stop by our website, www.sixfifty.com/privacy, and you will be able to set up a demo if you need a demo or ask questions if you're a current customer. You know how to submit those to us. So thank you so much.